out. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340. or 077-127-61884. BWF Solicitors, your trusted legal partner.
Hello. Good afternoon. Wherever you are welcome to Hanging Out with BWF Solicitors with your host, Vicky Newton. I have with me lawyer Eunice Achampong, who is a partner and also a solicitor at BWF Solicitors. And we are coming your way today to discuss another topic in relation to immigration. If you want to join in the discussions, you can do so on our Facebook page at BWF Solicitors and Vicky Newton, and also on YouTube at BWF Solicitors. If you want to call us live in the studio, the number to call is 0744 8619 711. And of course, you can also send in your message via WhatsApp. I will also entreat you to please share on all your platforms so that other people can also benefit from today's discussion. Today's topic, we're going to focus on international students. And what we're going to discuss is, can international students apply for their dependents to live with them in the UK? The topic is, can international students apply for their dependents to live with them in the UK? And as usual, Lawyer Eunice is going to take us through this topic and also give us guidance on how to go about an application. If that is possible, Lawyer Eunice is going to also give us the guidelines and how to go about this application. Lawyer Eunice, you're welcome to today's program.
Thank you so much, Vicky. I hope you're doing well.
Yes, I'm doing great. And you?
I'm doing well by God's grace. I just have a bit of the hay fever, which is annoying, but it's all good. I'm loving the blazer as well.
Oh, wow. Thank you so much. Lawyer Eunice.
Yes, and it's good to see the sun out. It's been raining these past few days. So thank God for the sun.
Yeah. Right. Yes, Lawyer Eunice, you're welcome to today's program. As usual, we always appreciate you taking time off your busy schedules, very busy family life, and coming our way to, educate us on issues in regards to immigration. But as we always do on this program, before we delve into today's topic, Lawyer Eunice usually, takes us through what the news is, what is going on behind the scenes in the past week. And I think before we came on the program, Lawyer Eunice also hinted me that there are some updates on the new statement of changes to the immigration rules, which was released, I think, just a week ago, 17 July 2023. So Lawyer Eunice will be giving us those updates as well. Please share, and I believe that every information here will be of benefit to someone on your contact. Once again, welcome, Lawyer Eunice.
Thank you. So,
Lawyer Eunice, take us through the updates.
Okay. So in terms of the updates, I know that a lot of us may have heard in the news regarding fee increases. And so when it comes to the Home Office fees, they have been still, or they have not increased over the past 3 or 4 years. And so since the COVID, the fees have stayed the same and not much has changed. But they have said that they are going to increase the fees across the board, just so that they are able to manage the pay increases in the public sector, and also it also goes in line with the cost of living crisis that we are facing at the moment. So they've said that in terms of the immigration health surcharge, they are going to almost double the fees. So if an adult was paying £624 a year for an immigration health surcharge, now that will be increasing to at least £1,035 a year.
Wow.
So if you multiply it by 2.5 years, you are looking at over £2,000 for just the immigration health surcharge, which is extortionate. So, I mean, over £3,000 will be just on that immigration health surcharge, excluding the application fee. And they have said that most entry clearance applications, most settlement applications, citizenship applications, leave to remain application fees will be rising by at least 20% of the normal fee rate that they are charging at the moment. So it seems like they are going to make some very drastic changes to the fees in the next few months. They haven't really given a date as to when these fee increases will take place. But seeing how unpredictable this government can be, I think we should be expecting it in the very next few months, because they have particularly said that immigration health surcharge increases are to fund salary increases in the NHS. So with the doctors and nurses going on strike, they have to find a way or means to be able to fund these salaries, and therefore they think it is right and proper to take these fees from immigrants who are applying to remain in the UK. And I know that not every immigrant pays the immigration health surcharge, especially within the healthcare sector. They do not pay the health surcharge because they are working within that sector in particular. So it will be affecting a lot of people who are applying for further leave or applying to enter the UK in any way, which form ever they choose to see it, they will be increasing the fees. I know a lot of people said it's very, very disappointing that still those who pay their taxes will have to bear the cost of these immigration health surcharges. Unfortunately, by law, because Parliament has enacted it, there is no way that those fees will not be charged, and therefore they have to be charged to those who are applying for further leave to remain. Yes. And then secondly, when it comes to, I know our EU nationals and EU family members, a lot of them would have received this week an email stating some changes to our immigration rules. And one of the changes under our statement of changes is to do with EU nationals and their family members who have applied for pre-settled status. So we all know that as a result of Brexit, the Appendix EU was introduced, there was the withdrawal agreement, and it was put into effect that all those who were EU nationals and EU family members living in the UK would have to apply under the EU settlement scheme to regularize their stay, because the residence card or the permanent residence that they held will no longer be valid. So any EU national or any EU family member who is residing in the UK or was residing in the UK before 31st December 2020 had the opportunity to make the application under the EU settlement scheme. And it was a requirement that the application had to be made by the 31st of June 2021. However, they opened it up to say that if you could provide reasonable grounds why you were not able to make the application by the 30th of June 2021, then you would obviously be able to continue with your application under the EU settlement scheme. But this change under the statement of changes is to do with those who have already made the application for pre-settled status under Appendix EU. So if you've made an application for pre-settled status or limited leave to remain, now the government are saying that they would now give you an extra 2 years if you are not able to make an application for settlement by the time your pre-settled status has expired. So there was a case in the High Court where the applicant made the application late for settled status, and they said, well, it means you don't have any proper leave. And under the EU regulations beforehand, because EU family members were seen as still living in the UK legally, regardless of whether they had regularized their stay or not, they didn't have to make an application, but most of them did because of work reasons. And so most of them would have done applications just because they would need to provide their employer evidence of their right to work. And so obviously they thought that they still had some legal standing because they obviously did the pre-settled status, but they didn't know that it had expired. And when they were making the application for settled status, they were told, well, in between that, your leave expired and therefore you don't have any basis to make the settled status. And they were told that that was wrong because the withdrawal agreement was done in such a way that it will preserve the rights of EU nationals and their family members here in the UK. So if a person has pre-settled status and was not able to make their settled status application in time, then it was necessary that the Home Office will obviously continue to see their settled status as valid. And so that is why they have brought this condition that if an application is not made in time for settlement, they may extend your pre-settled status for another 2 years. So they will extend it for another 2 years just so that it doesn't seem that you are making the application out of time. So those people who the system seems to have caught on that they are supposed to make the applications for settled status, or their time is up in terms of living here for a continuous period of 5 years, they will be alerted by being sent an email to let them know that they have lived here for a continuous period of 5 years, and all the records show that their evidence proves that that is the case, they would be granted settled status automatically. If for any reason the system doesn't show that all the evidence is available, they may request for the evidence that is missing, and of course you can provide it. They are saying that this will be enrolled by 2024, but I know people who already have alerts once their continuous period of 5 years is up. So the system has already started picking up on those whose pre-settled status has run out and need to make application for settled status. I think it's a good thing that the government is doing this automatically, just so that people don't miss out on making those applications in time. So that is good news for those who are EU nationals or EU family members. And also, they have also said that in terms of the validity of an application while under the EU settlement scheme, a lot of people would have come in to the UK as visitors, for instance, and thought, okay, I could switch to the EU route because, for instance, my husband lives here, and therefore I can switch and apply for EU settlement scheme and get pre-settled status because my husband and I were married before 31st December 2020, and therefore I have every right to remain here and apply to the EU settlement scheme. Yes, you may have been a family member before the 31st of December 2020, but now they are saying that from the 9th of August 2023, they will no longer allow such applications to be made within the UK. So if you are a family member and, for instance, your visit visa has expired and you are switching or you are making an application under the EU settlement scheme as a family member, you will be told that your application is invalid. And once your application is invalid, you will not be offered any right of appeal or administrative review or anything of that sort. So you would need to make sure that you make that application before you enter the UK. You don't say that because we were already the children of our sponsor or we were already spouse of our EEA sponsor, so we have the right to stay in the UK and make such an application because from the 8th of August, that sort of application will be seen as invalid. And I think a lot of people would not want to obviously hear that the application is invalid and therefore they can't continue. Because once the application is invalid, it means they will not even process it at all. You are not going to have the opportunity for the caseworker to even look at whether you meet the requirements or not. And a lot of people will obviously be disappointed if the application is just rejected because they are making it from the UK when they should have made it from outside the UK. I know it's a lot of bad news when it comes to these EU applications, but the government seems to be closing down on almost every route that they feel that people are trying to use to remain here, which is obviously sad for some of our clients. All in all, I think they are trying to make sure that people do the right thing when they're making their applications to remain in the UK. So that being said, there's also the fact that when it comes to making these EU applications, they want to make sure that as much as possible, those who made these applications, the EU route will make sure that as much as possible, if you are saying that you are making a valid application, that you are also showing them that you've made the requisite biometrics, you've obviously completed the online form, and that you've also provided your identity as part of the application process. So as much as possible, they want to make sure that all these things are also in place before you make the application under Appendix EU or under the EU settlement scheme. And for those who may seem to be Zambrano carers or Surrender Singh case law, should I say, roots holders. So Surrender Singh is to do with those family members who, for instance, are British and they went to live in another EU country, and because they lived there, worked there, schooled there, they now feel that it's time to come back home, and they've returned to the UK with their family members. That route is usually for those applicants who were family members to the British citizen but went to live in another EU member state for the period of time that the British citizen was there. And they also say that in regards to Zambrano applications, so those who are now making the Zambrano applications for the first time, they are going to close, yes, those routes by next month, because they think that it is only fair that those who are British citizens will apply under the immigration rules. So therefore, if you are somebody who comes under the principle of Surrender Singh, or you are a Zambrano carer and you are thinking about making an application under the EU settlement scheme for your family members or for yourself as a primary carer of a British citizen, then you need to do so before next month, because those routes will be closing down, and they would obviously ask you to make any further applications under our immigration rules rather than under Appendix EU. I think that a lot of primary carers, especially those who believe that without them, their British children would not be able to remain in the UK. So it means that they have to provide both financially and physically for that British child. And there is no other family member, like a father or a mother or an extended family member, who could care for that child here in the UK without the presence of that main primary carer. So it could be that both parents do not have leave and are applying as Zambrano carers, or it could be that it is just a single parent, and that single parent is applying for Zambrano as the primary carer of that British child. All those who think that they can make an application under Appendix EU need to do so before the 8th of August next month. So that is that in terms of EU applications and applications under our Appendix EU. When it comes to, I know that a lot of people are thinking about the student route. So that is our main topic for today. Just to say that once our statement of changes were released on the 17th of July this month, this was about 2 weeks ago, immediately they said that at 3 p.m., any student within the UK who wants to switch from the student route to the work route. So it could be that they are switching to the healthcare route. It could be that they are switching to the global talent route. It could be that they are switching to the skilled worker route, the minister of religion route, the innovator route. Whichever route they seem to want to switch to, they said from the 17th of July that from 3 p.m., no student who has not completed their course would be able to make that switch.
Okay.
So if you are a student here in the UK who came from your country to study and you have not completed your course, you would not be able to switch from your route to any work route whatsoever.
Okay.
And that also meant that those students who were not able to complete their courses
Mm-hmm.
obviously had no time whatsoever to make any adjustments or changes whatsoever. So it meant that a lot of students who were thinking of making the switch would have not been able to do so. And of course, it meant that a lot of students were stuck in terms of the applications they had to make. So it
Okay.
does cause a lot of havoc in terms of immediate changes, and that's why I said this government are very unpredictable. So they can bring about a change and they don't give you time to even um, implement any changes that you would like to make yourself. And therefore, it's important that if you have in any way made the application before the 17th of July, then you are safe. But if you
Okay.
were thinking about making a switch, then unfortunately that door has been closed to all international students who have not yet completed their course in the UK. And they've also made sure that if you haven't completed your course, you cannot also switch as a dependent of a worker. So if you think that it is just to the work route, unfortunately, it's not just to the work route, it's also
Mhm.
as a dependent as well. So if you know you have not completed your course, then know that you will not be able to switch as a dependent of a skilled worker or any worker within the UK.
So, Eunice, so if the students complete the course, let's say by the end of this year, they can switch. It's only focusing on those who did not complete, their course.
Yes.
Okay.
So if you
Okay.
did not complete the course, then you cannot switch because they realized that a lot of students were coming in, they were not attending their courses, they were not basically enrolled on their courses, for instance,
Okay.
and
Okay.
therefore they needed to make sure that people are not circumventing the law for their own purposes. And that's why they've said if you haven't completed your course, there is no way of switching to any worker route or switching to become a dependent of any worker.
Okay. All
Yeah.
right. Right. So, if you want to change your course, that
Yes.
doesn't affect you.
If you want to change your course until you have made a valid application, that
Mm.
means that, of course, your current leave is going to, as soon as you make that application to switch, so you've changed your course, you have
Mm.
to make an application to switch from the current course to the new
Okay.
course. You
Okay.
will definitely need to make sure that you receive a decision before
Right. Mm.
any switch to the worker route. So you can switch as a student but not onto the worker route.
Okay. All right.
Yes.
Okay. All right. So I think that answers the question I was going to ask you. Changes implemented in regards to students under the new, statement of changes to
Yeah.
immigration rules. Right. So, Lawyer Eunice, before I continue, you're done with your updates, isn't it? Because I
Yes.
realized we delved into the topic already.
Yeah.
So, which category of students have been permitted to allow their dependent spouse or children join them in the UK?
So when it comes to those that are dependents, they said that if you are already in the UK and you are making an application for dependents within the UK, you can go ahead and make those applications for different dependents. So no matter what category of degree you're doing, so whether it's an undergraduate degree, whether it's a postgraduate degree, master's or PhD, as long as you've started your course, you can still make applications for your dependents to join you. So they're saying that the change comes into effect from the 1st of January 2024, where students in general will not be able to make applications for their dependents, but those who are studying postgraduate courses that are research based will be able to apply for their dependents to join them. So for now, if you're already in the UK as a student or you are starting your course in the autumn of 2023, you can still apply for your dependents to join you here in the UK.
Okay.
So the change doesn't take effect until the 1st of January 2024. And it's important that we realize that when it comes to the change taking place from the 1st of January 2024, this applies only to those students taking postgraduate courses that are research based and those that are on PhD courses and those that may be government sponsored. So if you are government sponsored, you can also apply for your dependents to join you here in the UK. So if it's a postgraduate course, you have to make sure that it's a research-based course or a PhD, or somebody who is coming here as a government-sponsored student can apply for their dependents to join them. So in a way, they've provided a leeway for those students who are already here to make the application for their dependents to join them. So that's the good thing.
Okay.
At least they've provided us up until January of 2024 for dependents to continue to apply to join their family members who are students here in the UK.
Okay. All right. Let me give Eunice a few seconds break. Ladies and gentlemen, if you've just joined us, this is Hanging Out with BWF Solicitors. BWF Solicitors is one of your top law firm in the UK. They specialize in immigration and nationality, Ghana law and practice, dispute resolution, and many more. They are also one of the top 3 family law solicitors in the UK, and they've won so many awards, with what they've contributed to the community. So if you have any issues in regards to immigration, Ghana law and practice, dispute resolution, and many more, Lawyer Eunice at the end of the program will leave her details for you to contact her team. We'll book an appointment with you and take you through whatever requirements needed. Today's topic is, can international students apply for their dependents to come and live with them in the UK? And if you've just joined us, I think Lawyer Eunice is not a stranger at all. She's with us every time we come on this program as our resource person. She is a lawyer and partner at BWS Solicitors, and she comes here to educate us and also guide us on issues with immigration. Today she's here with us, and as I said, our topic, can international students apply for their dependents to join them in the UK? I would love to hear from you. You can contact me or contribute to this program via our social media handles on Facebook and YouTube at BWF Solicitors. You can also call us live in the studio on 0744 8619711. 0744 8619711. And of course, you can also send me a WhatsApp message if you are one of the shy types. I wouldn't mind, hearing from you, on WhatsApp, and I'll definitely pass on your question to Lawyer Eunice for her to answer your questions. May I also request, please share this program. I know what I'm saying because every time we have this program, I get people contacting me saying that, oh, a friend shared it on a group platform. And in fact, it's really very good information for them. So I believe that this program is, having an impact on a lot of people. So pass it on by sharing. Then, anybody you might not know who needs this information. Right, going back to the discussion. Lawyer Eunice, what requirements are to be met as a dependent of an international student in the UK? What are the requirements?
So as a dependent, that could be a spouse, it could be a child as well. Most of the time, if you're applying as a spouse, it is required that you show that your relationship with the student, the international student, is genuine and obviously is subsistent, so it's continuing. So once you've been able to provide evidence of your marriage, which is your marriage certificate, communications, if it's transfer of monies that you do to each other, provide evidence of that. As long as you are able to provide some sort of evidence to show that you are in a genuine and subsistent relationship, at least that requirement will be met. And then you also have to be able to show that as a spouse, that spouse has their own means of maintaining themselves when they come. So they expect that at least for the first month, they would have at least £285 in their account to show that they will be able to maintain themselves when they come to the UK. And if the duration of the course is for, let's say, 2 years, or you're left with a year, then you are supposed to calculate how much maintenance that person may need for that period of time left.
So, Lawyer Eunice, the 225, if I'm correct, is it every month?
Yeah, so 285 for every month. Yeah. Okay. And then if it's a child, usually they want to know if both parents are either already here in the UK, or the child is coming to the UK to join their sole parent, or the other parent of the child has abandoned the child or is deceased and therefore unable to care for the child. So if, for instance, I'm here in the UK as an international student and I'm making an application for my spouse and our child, then of course that means that the parent of the child is already in the UK. The other parent is applying to join the student, and therefore the evidence that you will be proving is that this child is a child of myself and my spouse, and this is the birth certificate to show that this is our child. So in terms of the children, you will have to provide the evidence that it is the child of both you and your spouse, or if it's the child of just yourself or just your spouse, you are supposed to provide evidence that that spouse or yourself is the sole parent of that child and the other parent does not play a role whatsoever. Or if the other parent is deceased or has abandoned the child, you will have to prove evidence that that is the case. So when it comes to the children, you definitely have to prove that they are yours and that you are the parent of that child. Either you are playing a joint role in the child's life or you are the sole parent in that child's life. And they also have to meet that maintenance requirement. So for the first child, they expect that there is at least £315 per month for the first child. And so if it's two children, then they request an additional £285 for that child as well. So you should be able to show that you'll be able to maintain the child for the period of time that they will be coming to live with you here in the UK as well.
Okay. All right. So will coming to the UK to complete a master's degree qualify me to bring my husband and children?
So yes, when it comes to master's degree, if you are not specific, obviously for now, as I said, the law takes effect from the 1st of January 2024. So if, for instance, I'm studying a master's degree now and I'm saying I want to invite my dependents, or it could be that I will be starting my master's degree in September of 2023. If that is the case, then yes, I can definitely invite or allow or apply for my spouse or apply for my child to join me here in the UK. If you are coming on a course which is starting from the 1st of January 2024, then it means that the master's degree that you are going to be studying has to be a degree that is research based. I'm not really somebody who is very research based, but I'm sure it's to do with subjects where you are required to do experiments and things like that. So if your course of study is a research based sort of course or it's a PhD, then of course you know that you can bring your dependents and your spouse, your children to come and join you whilst here in the UK. So it depends on I mean the start of the course. So if the person is starting their course this year, then that's fine. If it's from next year and their course is not research based, because we know that it has to be a postgraduate that is research based. If it's not research based, then unfortunately they will not be able to bring their spouse or bring their children to join them here in the UK. Yeah.
All right. Kojo is asked this funny question, but I know the answer, but I'll still put it to you. And he's just curious, who qualifies as a dependent? Is it wife, children, husband? Does it include parents, grandparents, cousins? That's what he's asking.
Okay. So obviously, if you are making the application to bring that family member to come and join you, it's definitely either your spouse or your child. So it's limited to just your spouse or your child. Um, some people may ask, maybe, for instance, I've adopted a child, and
Yeah.
will that be classified as my child? Yes, as long as you have the documentation to show that you went through the right processes and you have adopted this child legally, um, of course you can bring this child as your dependent. So it does not include your extended family members. It doesn't include
Right.
your sister's children or your brother's children or even your parents. So it's limited to just your spouse or your children. They are your direct line. So
Even though they depend on you.
yes,
Parents. Okay.
even though they depend on you,
Right.
it is limited only to your spouse and to your children, to the direct line. And so it shows how strong or important the family unit is. So when they made the laws, I'm sure they were thinking maybe it might be important that your spouse is with you when you're on a course like this, or your children are with you when you're on a course like this. So it's
Okay.
important that we understand that dependence doesn't mean a general term of those who are just dependent on you financially, but those who are termed as your spouse or children.
Oh, okay. All right. So, Laura Eunice, will a dependent spouse or child be granted the same leave as the student?
So that is usually the case. If, for instance, um, I'm coming to the UK as an international student and I make the
Mm-hmm.
application at the same time as my spouse, then it means that we will both be granted the same leave. Or it could be
Right.
that the international student is already in the UK. So they are on a 2-year course. They've
Mm,
already spent 6 months on the course and they are now making the application for their spouse or for their child to join them in the UK. If that is the case, if they are now making the application, once the application is decided, they usually say they have a period of 8 weeks to make a decision, but it may
okay.
sometimes take longer than the 8 weeks that they are uh, suggesting. And so it means that once a decision is made, they will calculate the time that is left on the spouse's leave. So the international student, if he's left with a year and 3 months or a year and 4 months, that same leave will be calculated, and then
Mm,
the spouse who is coming, or the dependent who is coming, whether it's a child or a spouse, will be granted the same leave as the student, so that both student and spouse either will leave the UK at the due date, or
mm,
they can apply for further student visa, or they can apply for work visa once their course has been completed. So
okay.
they do it such that both of you are able to end at the same time, and then the course
Mm,
um completed so that both of you can leave, because we all know that student visas don't lead to settlement. So if you're here as a student, yes, the graduate route is open to you. Yes, the work route is open to you, but only
yeah.
if you complete your course. So
Mm,
now the emphasis is on completing the course, because if you don't complete the course, you cannot switch to either the graduate route or the skilled work route.
okay. All right. Right. In the absence of no more questions, Laura Eunice, just give us a brief, just a summary of what we discussed so far, for the benefit of those who just joined us towards, the end of this show.
Okay.
Just give us a summary of what we discussed so far, and also very, very important to leave your details for anyone who wishes to, book an appointment to come and see you for further, assistance and guidance, can also do so.
Okay. So when it comes to what we were discussing today, it was to do with the fact that most students would have come here and would have come with their family members, or would have wanted to ask or apply for their family members to join them. As the UK government is trying to limit immigration numbers, they have
Mhm.
said that by the 1st of January 2024, applications for dependents will be closed to those who are not studying postgraduate courses that are research based, or
Okay.
courses that are PhD or courses that have been sponsored by the local government of that international student. So if you know you are entering the UK as a student by the 1st of January 2024, know that dependents may not apply with you, or dependents may not later on apply to join you if your course is not a postgraduate research-based course. And it's also important to know that it is still open for those that are already in the UK or those that are going to start their course in the autumn of this year.
Yeah.
As we always say, this program is not just for immigration, but we as a law firm also practice in other areas of law, including family law, and we also deal with some employment law issues. And our barrister and solicitor here in the UK, he's a barrister of law in Ghana, and also a practicing solicitor here in the UK, and the head partner of BWS Solicitors, Mr. Bernardo Wusu. He also deals with wills as well. And so if for any reason you have any issues in any of these areas, you can contact us on 0208 493 7340. So 0208 493 7340. And we have our offices open from 9:30 a.m. to 6 p.m. and it's always open from Monday to Friday. And if you want to come and see us, we are situated in London on the 4th floor of Anna House, 214 to 218 of Tottenham High Road. Our postcode is N154NP. So N154NP. And if you want to call myself out of office hours, my number is 075 35 81 3910. So 075 35 81 3910.
Thank you, Lawyer Eunice. Viewers, we've come to the end of this program. I would like to show someone sent a message and that has got nothing to do with the program, and it's very funny. My apologies. I got a bit distracted. So ladies and gentlemen, thank you so much for tuning in, staying with us throughout the program. We very much appreciate you. If Lawyer Eunice, as Lawyer Eunice mentioned, if you want to see Lawyer Eunice, to seek more advice and guidance, her number is on the screen. Do not hesitate to contact her. And for those who joined us towards the end of this program, you can watch a recorded version on our YouTube channel at BWF Solicitors. You can watch from the beginning to the end. And if there's anything else you feel wasn't clear to you and will want to seek more clarification, feel free to call Lawyer Eunice on the number on the screen. Thank you so much, Lawyer Eunice. Thank you on behalf of the community. We also want to extend our great thanks to you for always being there to, guide us and advise us, on immigration issues. This prevents a lot of people getting to the wrong side of the law. And for that, we very much appreciate you and your team. So, so we hope to come your way next time with another interesting topic. Take very good care of yourselves. And until then, stay blessed. See you later. Bye-bye.
Bye.
This is our world. Here we are in our community. There are the laws. There are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London. N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.